Hello everyone, I'm Natalie Cooper, Editor of Changeboard. Welcome to our Changeboard webinar series. Today we're joined by leading employment law expert Stuart Chamberlain of Kroner. He will be talking about all the latest employment law legislation implemented by the coalition government since 2010. He'll also cover employment legislation due to come into force in 2013 and how best to prepare. We also have a hashtag Kroner capital E-Law, that's Kroner E-Law, because we'll be live tweeting throughout this webinar. So thanks for joining us today, Stuart, and over to you.
Thank you very much indeed. Well, good afternoon, everybody. As was explained, I'm hoping to cover really government employment policy and what they've done so far, what they seem to be doing, really acting as a, if you like, a checklist for all of us to know what we should be doing at the moment and in the future. So the first part, I really want to deal with what government policy is, and my slides just act as for you to just follow the main points of what I'm saying. Before I even start about policy, I'll put the first slide up. But one of the problems with all of this is that, of course, we're overwhelmed with consultations, as we'll see, and that you know, we're not often sure whether the consultation, which one we're in, and what's happening. They often change as they go along, and not least, there's uncertainty both between the coalition partners and what the policy should be. So that's a problem. The last little point I think we should mention is, of course, we don't know when some of these things are coming in. So I said, the first point I'm going to make it, if you look at the screen there, is what are the problems for the employers? Law policy, the immediate actions after the general election, when they seemed to, it was likely they'd throw away most of what the government had done, the Labour government had done previously. Then I'll have a look at what measures came in those two vesting times during the year, April and October of this year, and then we'll have a look, and there's quite a lot about that, of the new legislation that's coming up. Points, because from the government itself, one of their numerous consultations, they drew up a whole list of problems they thought employers faced. And the first one is very interesting because throughout the documents there seems to be a theme running through which says that people don't take on staff because they're frightened of the cost of unfair dismissal. Now, I'd be interested to hear what you think about this one. It's certainly not one that, as an employer in the past, I've ever particularly worried about. The last thing on my mind when I employ somebody who I think is going to be good at the job is whether I'm going to sack them next week. The second point, of course, and this is quite right, fear of the threat and the costs of carrying out an employment tribunal. And it's particularly problematic, of course, when dealing with performance, or more to the point, underperformance. And I'm sure we all know, don't we, that dealing with managing performance can be a long, drawn-out process, series of meetings, telling people to improve, setting them time scales, giving them warnings, having another meeting, and then eventually perhaps getting round to dismissing them with all the risks that that incurs. And all of this creates uncertainty in business planning, obviously. The next point that the government made, as a Kroner employee, I make no comment upon about the need for external advice. And the last point is difficulties in navigating immigration system. Well, we're not covering that in this presentation. So if you go back to the time around 2010 when Dave and Cleggie got together over this matter, I think we can find what their policy was. They'd actually wrote it down a number of times. So there we are. First of all, always came first, remember the background to the general election, it might still be a problem, is to act on bankers' bonuses. I'm not going to comment any further upon that in case I make a typographical error. But I would say I leave it to you to think whether or not the government's actually done anything on that. Cut red tape. They've undertaken something called the Red Tape Challenge, which underpins much of what they're going to do. Well, every government says there's too much red tape. We want to reduce the regulatory burden. Nothing new there, I suggest. Review workplace law. Yes, often governments want to do this. Well, in fact, the government, Mr. Cameron, instituted an employment law review which looks at what's coming in, what's going out, what's replacing what, etc., produces reports. It lasts through the whole of this present Parliament. The next point, which has been the source of considerable worry in the Daily Telegraph in 2011, was ending the gold plating of EU law. And by this I mean that we introduce measures that are above and beyond what we're required to do in respect of European law. And then, of course, they were to put a cap on immigration. I did notice the other day that Ms. May, the Home Secretary, threw up her hands about what they were going to do about all of that. So we've dealt with the policy, what the government thinks. I wonder if anybody would like to make any comments, or, well, comments would be very welcome.
So I have a question for you, Stuart.
Yes?
Why don't you think people are constrained from recruiting staff because of employee rights?
Well, I just don't think this is so. I think it's, if I can be frank, I think it's underpinning the belief of the government that they need to do something. They think probably that the balance, wrongly of course in my view, that the balance is in favor of the employee rather than the employer, and that people spend the whole time worrying in case you know, ambulance chasers take up the cause of people. I just don't think it's like that. I think most people in good faith take on staff and hope that they'll work well and train them to do that. You know, there are exceptions, as there is in everything. But I myself wouldn't want to rely on this as the basis of the policy. Okay, well, thank you for that. We'll now move on, and I want to look really at what the government did, just to remind us all about what the government did straight after the general election in 2010. Sorry. Of course, the Equality Act was brought in by the Labour government, and it had quite it consolidated all the various strands of anti-discrimination law. The government, the coalition government, decided not to bring two things in, really. And in fact, as it turns out, we'll see later on, there's quite a few things that they now want to get rid of as well as part of the Equality Act, but we'll leave that for the time being. The things that didn't come in, of course, were dual discrimination. You can't claim for both sex and race in the same claim. And secondly, large companies were to make reports about gender pay and how it affected them or how they're failing in that. That's and the overriding social background to employment law that was favoured by Mrs. Harman, that Harriet Harman, didn't come in either. So vetting and barring scheme, this is, if you know, the CRB checks, and there's been quite a this September we had some more details of what they're going to do. The government and Mrs. May, the Home Secretary, said it was a ridiculous situation they got themselves into, checking up on everybody, and a common sense approach was required. And in fact, some partial changes have come in this September, and there's going to be further changes in December 2012. I won't be dealing with that in all much detail. If you do want to find out about what the changes are in the vetting and barring scheme, you do need to go to their particular website. Third thing they did, which was applauded, was to remove the retirement age. Of course, you can still have a retirement age if you're an employer, long as you can justify that. We've had quite a lot of European cases, one or two in the UK, and I have to say that in my view, they're all two extreme cases. You know, judges, football referees, collective agreements and age retirement in Germany aren't what I'm looking for a bit of guidance on objective justification. I'd like something about a middle manager in a large retail company, because I think that would help us. And to my knowledge, we haven't had any cases like that to date. So just to say, of course, that the government hasn't given up on it all, because it says it's going to review the whole question of default retirement age at 2015. The third thing it did was merely as an interim measure, and it's gone further back, as we will see, which was additional paternity leave was introduced. It didn't introduce, as it said it might have done, extension of the right of flexible working to all, but as we shall see later on in the webinar, that's coming in later in the Parliament. Agency workers regulations came in 2011, put new demands on employers to follow the regulations and to sort out what the employment law responsibilities are there. They are supposedly, I haven't seen much notion of this, the paperwork responsibilities and requirements of that are to be reviewed sometime this year. It may go into next year. There's also a moratorium on new legislation affecting micro, that's fewer than 10 employees, from April 2011. I don't think much of that has actually affected major themes of employment law. And just a last one here, the government did publish, you can download it, it's only 2 sides of A4, something called the Employers' Charter. And it's intended for small employers, and it's intended, it says, to help employers understand what they can do in general. Of course, they then give the caveat that individual circumstances may apply, and it says you can get rid of people for performance. It doesn't say how, and it says all sorts of things like working with agency workers, making somebody redundant, but unfortunately at the top it says you can do all of this as long as you act fairly and reasonably. Unfortunately, of course, as you know, the moment the word reasonably comes up, that means you have to pay a solicitor a lot of money. Okay, let's have a look then, and we don't get too bogged down in this. Let's have a look at the government consultation and legislative changes that have taken place over the last 2 years. And really, this is full of detail, and I could have made it twice as complex because I think there's all sorts of things still going on. At the top there, this is just to remind us really, the Employment Law Review, which is going on throughout the life of Parliament. It has annual updates. If you can afford the stationery, you can run it off each year, and it's got some nice little charts. There's the Resolving Workplace Disputes, which the consultation lasted during last year, reform of unfair dismissal regime and tribunal reform, financial penalties for employers. Ask your views on this. Some things have come in, some are coming in. Modern workplaces, that's more to do with what's to come in the future. We had all the fuss about dismissal with no risk of tribunal for micro businesses. This is Mr. Beecroft. Of course, that was dropped in its pure form as being unworkable. Certainly Vince Cable didn't like it very much. We've got consultations now following the call for evidence on the dreaded TUPE and on collective redundancies. We've had consultation and more on compromise agreements, or settlement agreements as now to be called. And of course, in the field of discrimination or anti-discrimination, things that were in the Equality Act are still going to be removed. And that is, of course, removal of third-party harassment. That is, 3 strikes and you're out. So there's 2 instances of harassment in an organization. And if the employer is warned, all these by a third party, of course, who may not be the same person, but if the employer is put on notice of this and does little, then if it happens a third time, the employer is liable for that discrimination. And of course, the government intends, and they're out of consultation on this, to remove questionnaires in discrimination cases. That's quite controversial, really. Okay, so we've dealt with what immediately was done. Now's the time for a poll where we ask you, and there's only one of these, but I think it's straight to the point of what I've been talking about. Do you feel confident in dealing with underperforming staff, or does regulation make you hold back? Would you like to do things properly, or is it that you know it's going to be long and you're frightened it might end up in a tribunal? If you can see we're not allowed to vote, but if you'd like to put yes or no, the organisers will take that into account. Thank you very much if you'd like to do that now. Okay, thank you for that. Thank you for contributing to that. Here we are. You do feel confident about dealing with underperforming staff. Good. I think we probably ought to send the results to Vince Cable, because as I've said before, I'm labouring this a bit, but it is true that the majority of you do feel confident and not held back by case law and regulation. The whole basis of this is what's coming in, and we probably think, don't we, we've got enough as it is to be going on with. That's quite satisfactory. For those that don't feel so confident, well, you know, you just have to think about it harder, I think. Perhaps what the government measures doing will help you out in that. So the next step is looking to what came into force this year. So first of all, the changes in April 2012, two major things really. One, increase in awards. So that's the annual hike-up of what the compensation and the financial award should be for anybody at the tribunal. And as you know, just to round it up, it's over £73,000 now if you get the top whack of the tribunal, which is highly unlikely actually. But it's good headlines, but most people don't get anywhere like that. The second intervention was perhaps more controversial again, and that is the increase in the qualifying period. I'm old enough to remember when the qualifying period went from 1 year to 2 years before, and of course cases were taken by what was the old Equal Opportunities Commission to Europe, and it was found to be unfair on grounds of sex discrimination. But what it is a big, for you people in HR and employment law, it's a nuisance, because what you've got, of course, it came into force on the 6th of April this year. Anybody employed after that date has to have 2 years to bring claim for unfair dismissal where a qualifying period of service is required, not for automatically unfair reasons, because there's no qualifying periods there. So anybody who started on the 6th of April and onwards now has to have 2 years for the usual reasons of dismissal. However, those of your staff who were on your books from the 5th and before can still rely on the 1 year. I don't know how people deal with that very carefully, but it does present certain problems, and it's certainly not very neat. The second area that came into to be changed was the start of what is a long process of employment tribunal reform. I have to tell you, I'm not a young man, as you can see from my picture, and I'm surprised that so many, having seen me in the picture, that so many of you still wanted to hear me. Nevertheless, we've had so many changes in the employment tribunal field of reforms to make it more effective, to make it more receptive, to make justice quicker. Well, we're off again. And of course, these measures have already been taken in. Increase in the deposit to £1,000, costs risen from 10 to 20,000 against unreasonable and vexatious parties. And there are some people who sort of take a professional delight in bringing as many cases as possible. Thirdly, a measure that's supposed to increase the speed in which the tribunal can take place, and that is we don't have to have witness statements read out anymore. They can be taken as read. The last one I'm not so sure about, and in fact the whole question of employment judges sitting alone in unfair dismissal cases has already led to criticism from the EAT. And the approach of the EAT in a case in Scotland, Lady Smith, the judge there said, president of that, the leader of the EAT in Scotland said, well, I thought it was an industrial jury, and the wing members bring important experience to the whole game, and you shouldn't rely on one person. So some aspects of this are not sitting easily with the judiciary. Anyway, they're probably going to the EAT with their reform. So I have to tell Lady Smith she'll be probably sitting on her own all the time now. Now we come to October 2012. One thing I haven't put in here that you might like to remember that isn't part really of employment law, but the extension of age discrimination to goods and services. So I'll be looking for a better service when I get home tonight, but that came into force. Three things really. I'm not an expert on pensions, so it's no good. I would be frightened to ask anybody. But of course you know that we've got auto-enrollment. It was well advertised on the television and the radio. It's a sequential thing. Larger firms are starting and have to offer this. And if you're a very small firm, it's going to be, I think, probably 4 years or something before you have to implement. But you ought to look up and read up to see what's required, because I'm sure it will come to a workplace near you. Secondly, minor changes to the national minimum wage, which needn't concern us. I'm sure you're aware of that. And then thirdly, changes to the vetting and barring scheme, which I've mentioned before. It's all consolidated. You don't have to make a check-up on everyone. And of course, I mean, I don't wish to make things more difficult for people, but Jimmy Savile would never have been challenged on this. So, I don't know. That's just one example, one very difficult one. But there are things easier for you to employ staff rather than have to wait for ages while the police clear them. Okay, well, there's another time for another break now. Is anybody want to make a comment or ask a question about anything that came into force in April or October this year? I'd be delighted to answer as I can.
Yes, there is a question that's come through actually. It's what do you believe will be the impact of the increase from 1 to 2 years in qualifying service to bring a claim of unfair dismissal at the tribunal?
Yes, well, I think thank you. That's an interesting question. And if I was faced with advising somebody who obviously hadn't got the 2 years qualifying service now, I'd be faced with a problem. Because even if it was a very nasty dismissal, I would not be able to argue that. So I'd be looking at some other approach. Now, one thing is certain: over the last few years, we've seen a big rise in the number of composite claims. That is, you don't just go for unfair dismissal, you go for everything else that you can, and if you can occupy the employer enough in that, they'll give up and settle a large amount. Well, that's the tactics of those who represent the employee anyway. So I think that without the possibility of claiming for unfair dismissal because of the 2-year, we'll have to explore other avenues, and it may well be, as has been widely publicized, that there'll be more claims on discrimination in whatever strand. So I think that's probably the answer to that one.
Thank you, Stuart.
Okay, now I'd like to have a look at where we are as we read every day about what's actually coming in this year, next year, and in fact right to the end of the Parliament. Just to set this in some kind of context, if you look at the Queen's speech in May, where much of the legislation was laid out, although I have to tell you, things are added on, as we shall see. 2 main pieces of legislation were to come in: the so-called Enterprise and Regulatory Reform Bill, that's before the House of Lords at the moment, and I just checked before we started, I probably think much of that will come into force next year, but I am a gambling man myself, you just don't know, but that's what it seems to say. There's also changes to discrimination, which is going to be under the Children and Families Bill, which I think is going to be published in 2013 and probably coming into force in 2014, but we'll have to say. Vince Cable's announcement, of course, in September, and he really said, I'm staying here to look through these, to follow through these reforms, and there is the balance of what the government stands for. And of course there's tensions within this, and that is hiring staff while protecting basic labour rights. I leave it to you as we go through this as to whether much of that is going to be achieved. The centrepiece of all the changes is really the so-called compromise settlement. And that is, I think in shorthand, it's compromise agreements but dressed up in a different way. And actually quite different in their approach, because what you'll be able to do is to, before there's any dispute, if you don't like the way somebody is performing, and I don't know whether it'll also include people who are getting too doddery to do their job, but you can say to them, well, we're going to have and this comes into play also. Protective conversations have now been incorporated into the bill. So I have a conversation with my employer and I say, well, things are not going too well. I don't think you've got a future here. And by saying this, I don't run any risk that this is going to count against me when I do dismiss you for underperformance, and they say at the tribunal, oh, we always had it in for me, and gave me no chance to improve. So the idea here is that you can be safe from future action against you for what you suggest to an employee. Now, that's all I can say at the moment, because what I think we do actually need to look at is what the government's going to publish. There's been a lot of talk about without prejudice and how different are these from compromise settlements. We don't know all the answers there. What we do want to see is the principle of guidance. There is a consultation paper out from the government, and I want to see the model documents and letters, because it may be that it's not as all-encompassing as the government hoped. So there we are. Compromise settlements, protected conversations are in the pipeline for this. So they're to be used before any formal dispute, and of course that's slightly different from the current system. The next development in the bill came as quite a surprise, and this sort of from right field, literally, where George Osborne announced that he was going to introduce a new employment status called the owner-employee status. Supposedly, this is aimed at small and medium-sized enterprises, and what it means is, in return for giving away all rights like unfair dismissal, redundancy, etc., you can have shareholding in the company. I want to see more detail. Some details have been published, but I say to you, if before you get excited about this, you want to check up on a number of things. And I put voluntary. It is voluntary for existing employees, so you can't just introduce it without them agreeing to it. But it gives you the opportunity for all, if you want to do this, for all new employees to take them on this employment status. Well, I don't know how some of the problems are going to be resolved. I mean, who unless they had to, would ever sign up to it? Do you actually want shareholding if the company is not doing very well? What happens at the end of the scene? How do you sell off the shares? So all these types of problems need some resolutions. I haven't seen them yet. Nevertheless, they're likely to come into force, according to George, in April 2003. There is consultation. We need more details. Anybody like to ask? Another opportunity for questions, if anybody would like to ask about that.
Yes, there's another question that's come through, Stuart. As the proposed new employment status of owner-employee is voluntary, why on earth would anybody sign up to it?
Oh, right. Well, somebody must have been listening to me over that one. Well, quite. Why would anybody? It's quite obvious that the trade unions and any sort of straight-thinking person wouldn't see this as being very good, because why would you want to give up rights that some of them, I mean, discrimination rights, if they're taken into account, are derived from Europe. And can you just sign them away? I don't know whether you can. So there's sure to be some kind of litigation about some of these, when and if they come in what form. But I really say have a look at what the consultation says, and we need more detail.
Okay, thank you, Stuart.
Okay, it's not just about the 2 points I've mentioned there. There is other parts of the Enterprise and Regulation Bill that we should just mention. I've listed them there. Some cause me concern. Every claim to the tribunal, that's those that get there, of course, are going to be mediated by ACAS. I don't know whether they'll be able to deal with all those, but that's a high level of responsibility for them. There's also, and this is going to be consulted on, as is the ACAS mediation, might be a job for me here after this, but rapid resolution scheme whereby there's an alternative to the employment tribunal, and it can be decided by experts called legal officers. They won't deal with very serious matters. It'll just be things like working time regulations, as if they weren't serious. Then there's going to be financial penalties for employers who are naughty in employment law, and particularly if they're aggravating. We've had a little detail on that. We probably need more on what actually constitutes aggravating. It could be anything from £100 to 5,000, and it must equal whatever financial compensation they get from the tribunal. Of course, there's a lot in it because it's to be paid directly to Her Majesty's Treasury. So this is a way for George to get a bit of money back from errant employers. We need, again, more detail on that. Lastly, about whistleblowing, quite in the relevance with people talking about what's happening about the price of oil and so on. One of the things that employers don't like is that at the moment a whistleblower can actually complain about a breach of his own employment contract. And so what the government is deciding to do is to introduce a clause within the Public Disclosure Act that will limit disclosures to those in the public interest. Although I have to say at the moment they haven't quite defined what that is. We again wait with interest. So again, it's just a brief opportunity to look at the bill itself, the Enterprise and Regulatory Reform Bill. If anybody's got any questions, I'd be pleased to answer them.
Yes, Stuart, there is another one. Can you foresee any potential problems with the proposed new settlement agreements?
Yes, I can, because it doesn't. This is where the compromise agreement, which is well established now about who needs to do it, who's got responsibility, it must be in the terms of where a grievance or an action is already taken, as does without prejudice. I think this is a new thing. It might seem to be in favour of employers, but I don't think we like the idea of taking somebody in a room and saying lots of nasty things to them, and then you're not liable for what you say. I think that will create considerable distrust. But again, we need more evidence to see what's actually going on. Consultation then, the next to go on, also within the Act, the bill, consultation on the level of unfair dismissal awards. As you can see, all of that. Does it actually address the real problem? Well, the real problem, of course, is what we need to do is to have fewer people going to employment tribunals, because the workplace is the effective place to deal with these problems. I know the government would like that to be so, they always say so, but I think that's the answer, not dealing with the level of awards. I'm not sure that any of this makes it easier to dismiss staff, because I think that cunning barristers will find ways round that. Well, one thing that's slightly worrying is that there is a proposal that, dependent upon the size of your company, you'll be liable for the award, so there's a sort of sliding scale of means. That doesn't happen at the moment. I don't know whether it is going to. On the next slide, which is a continuation of what's already happened, further streamlining of the employment tribunals. A past president of the EAT, Mr. Justice Underhill, carried out a fundamental review earlier in the year. It's now out to consultation. It's a long read. What's it all about? It's about cost savings, cost effectiveness, making things simple, making more possibilities for mediation, making people not necessarily go to the employment tribunal, but to some other way. Easier for judges to throw out weak cases. You've got no chance, you're not going to proceed with it. Reduce the number of preliminary hearings where they discuss whether or not to take the case forward. And then, most controversially, fees. And again, well, if you bring a discrimination fee, it's going to be $250 to bring the claim and $950 at the hearing. So you don't need to tell me that in a time when not everybody's earning a great deal of money and you're treated badly, that's a big tax on somebody if they want to go to the employment tribunal. So, you know, there'll be concerns about that. The government also is, I haven't put this down, but is addressing one of the almost laughable points about employment tribunals, which is, if they award you money, it's very difficult to actually get it awarded to you if the employer refuses. And so they're looking about late and non-payment of tribunal awards and perhaps introducing more legislation. And we'll have new forms. Anyway, all of these, we need more information about that. Have a look at what's going on. It'll be a lot to write about. I mean, again, it will be challenged. Now, I don't know, last chance for the final bit as to anybody who has a question on any of those.
Yes, Stuart, we've got an interesting one coming through. Are you happy with the concept of employment judges sitting alone in unfair dismissal cases?
Yes. I make my position, I agree with Lady Smith. I don't think it should be one judge. Pardon me. The whole system was brought into being where you had somebody who was a professional lawyer, the wing members, one came from industry, one from the trade unions, etc. They brought their wisdom and experience to judge the cases as the industrial jury. And okay, finally then, we're coming towards the end. Give you the opportunity for any more questions at the end. But what other future developments? Well, Cleggie's just got that on board now. He announced it only 2 days ago. And although it had been, we all knew what was coming into force, but there we are. Two main things: a new flexible parental leave arrangements. And so I think what's important here, forget all about the 18 weeks and so on. There's 52 weeks, 2 weeks after the birth, the mother, that's her maternity leave. After that, they can mix and match for the rest of the year. That's the proposal. 9 months of that will be paid, and that's coming into force after consultation in October 2015. So we know where we are on that. Before I started, there's plenty of blogs about that, and you know, saying whichever side you came from, whether it's good or a bad thing. Flexible working for all. Some employers see this as a bit of a problem already, particularly in small firms where not everybody, you're limited to 17 years at the moment, or 18 if they're disabled, and some carers. But now anybody, including those who are, you know, grandparents and so on, can apply for, will be able to apply from 2014 for flexible working. At the moment, we've got a system which is quite formal. The current statutory procedures will go, but the business reasons, the 8 business reasons that we have now for refusing, will remain. And the government is to help us. It's going to publish guidance before this provision of the Children and Families Act come into force. And then we've got, I've already mentioned this, go through quickly, further developments, abolition of third-party harassment, the questionnaire procedure, and what was in the Equality Bill, if the Employment Tribunal doesn't think things are going well in something like equal pay and there's a problem, it can make a recommendation to the employers. Pay audits, back to something that they didn't implement but now are interested in. Plans for extension of paternity leave, and that is not parental leave, paternity leave, which I talked about at the start, has now been put back right to 2018. So I don't think we need to think about that too much. And of course the EHRC, Human Rights Commission, their future is in some dispute. The next thing, review of paperwork obligations of agency workers, and then redundancy. The government and the employers have been strong in lobbying the government on this. 90-day collective redundancy obligations, too long, and the government has said it's either going to be 30 or 40. I don't know which of those it's going to be. Changes to TUPE, 2 big areas, I suppose. I think probably it's going to be changes some obligations about information, it made easier. But there's 2 big areas that, of course, employers don't like. One is post-transfer harmonization of terms and conditions. Most employers would like to change that. Well, my view is you can't. Most of this derives from Europe. We've got plenty of case law from what was the European Court of Justice, now called the Court of Justice of the European Union. And, of course, even in the 2000 regulations when they were implemented, Mr. Blair, Tony tried, but harmonization is not possible. The one thing they might be able to introduce was something that, again, the Labour government introduced to make a level playing field for everybody, which is the second kind of transfer, not the standard transfer where the economic entity applies, but the service provision change, where it's contracting out, contracting in, second generation contracting, etc. And we've had some very controversial and difficult cases already on this. This is an example of gold-plating European law, because there's only one transfer required by the original directive. So that may be subject to some scrutiny. And then lastly here, the government better get on with it. We've had all these cases in Europe and so on about long-term sickness and your holiday, popularly called the Barbados issue. So I'm on holiday in Barbados, and I suddenly ring my boss and say, I'm not feeling very well, so the rest of my time here is going to be taken as sick leave, and I'm rolling over the rest of my holiday leave into the next year. And of course, even though the employer has an apoplectic fit about this, of course, under European law, somebody is probably entitled to do it. And in fact, they are if they're in the public sector already. So the government's going to make the necessary changes about all of these, the carrying over of leave into another year, and they really ought to get on with it. They've known about it now for 2 or 3 years. Okay, well, I hope that's helped in seeing where you are. In fact, as I said, to act as a checklist of what we're doing and what we ought to be doing. And of course, if you can't sleep tomorrow night, I recommend that you have a look through my notes when they're sent to you. thank you very much for all of that. If you've any further questions, I'd be pleased to answer them as I can.
Yes, Stuart, there's a couple that have come through. One says, what could be the possible changes to the GP regime?
Yes, well, I think I said that, in my view, I think that the employer liability, where you have to give details, the transferor, that's the original employer, has to give details of the workforce that's assigned to the contract and transferring to the transferee. That's given at the moment at 14 days, and people think that's too late to notice. There may be changes to some aspects of information and consultation. I don't think we're going to get any change in post-transfer harmonization, much as it might be welcomed by some employers. The one area I think that is possible that there should be a change, although it was introduced to, as I said, to make a level playing field, is the second kind of transfer, the service provision change.
And then there's another one.
So my money's on that one.
Okay, sorry. Yeah, there's another question. Overall, will this raft of employment measures, here's a question for you, make it easier for employers to recruit new staff or make it easier for employers to remove staff, particularly underperformers?
Yes. I wait to see whether or not any of these measures actually make any changes to the case law on underperforming staff. I mean, not every case of underperforming staff ends in dismissal or needs to be. There is some people where they need to be helped, and you've got to give them the time and the support and make it clear to them what's required. And I think some of the measures are probably too populist. I'm sympathetic for those who think they can't get rid of staff. I'm not convinced yet that we don't actually have the measures already, and we might be really tinkering around with something that perhaps needs to be all right anyway. Although I'm not complacent, and I know that some employers feel very strongly that there should be these changes.
That's great, thank you. So, Stuart, I think that seems to be the end of the webinar. I'm sure everyone will agree that was a very informative webinar. Thank you for your insights, and thanks to all for your taking part, listening in and providing some great questions. I just wanted to remind everyone that we will be sending out the presentation and webinar link tomorrow. So all that leaves me to say is enjoy the rest of your day. And Stuart, would you like to say any final words?
Yes, thank you for everybody for listening through. As I said, when you receive your notes, if you can't sleep, they make an excellent alternative to Horlicks. Thank you very much indeed from all of us at Kroner anyway. Thank you.
Brilliant. Thank you very much. Thanks.